Keeping your business healthy in today's marketplace can be a challenging and overwhelming task. From the threat of litigation inside and outside your organization and the inefficiencies that can rob your bottom line as a result of unproven marketing programs, the deck can be stacked against you. To get ahead of these challenges and stay ahead of your competition, the Bottled Business Sense Show provides practical business solutions that uniquely emphasize key legal principles, management techniques, and marketing strategies to protect and ensure the longevity of your business. You'll learn how to implement marketing and protection principles equal to those used by today's most successful corporations. Join your host, Bill Bernard, Rick Moscoso, and Steve Smith for some high-energy discussion that will inspire you to take control of your business so it can prosper in today's consistently challenging business environment.
Good morning, everyone. Today is Tuesday at 10 a.m. here on the Bottled Business Sense Show. I am Rick Moscoso, one of your co-hosts this morning. I want to welcome everyone here to the show. We broadcast here every Tuesday morning, and you can find us also on social media at our website, social media on Google+, Facebook, on Twitter at BB Sense Show, and also our website at Bottled Business Sense Show. And every Tuesday we come to small business owners and talk about marketing, business practices, video marketing, and legal topics on how to go about running your business efficiently and also protecting your business that will help you run prosperously. So with that, our topic today is by one of our legal experts. Actually,
what do you mean one of our legal experts? What's
the only legal expert?
Yeah.
One of our legal. Somebody's practicing law without a license here. I don't know who.
Excuse me for that. I misspoke.
Hey, Bill. But what we failed to tell you was this is the only show you're on. We have two others where we have other lawyers on.
Yeah. Well, we have one local legal expert who lives here in Southern California, and the other one who's sitting in the Aloha State. Mr. Bill Bernard. So with that, I'm going to turn the mic over to you, and why don't you welcome the audience?
Well, thank you very much. And they are one and the same, ladies and gentlemen. I just have two different offices, and I am in the state of Hawaii, and I'm not going to be apologetic for that whatsoever. I'm here, and I'm working hard, and nobody believes that, but it is the truth. I'm an officer of the court, so you can take me at my word. But I thought I really wanted to do this show because I think it's important. But I would really truly be wealthy if I got a dime for every time someone asked me the question, gee, I hate my boss. He's rude to me. He's nasty to me. He swears in the workplace. He's rough on me. I can't stand my boss. He's made me quit my job. What are my alternatives? What's my quote-unquote cause of action against this guy or gal? And so that's why I thought we'd talk about constructive discharge, not only in terms of what an employer should know, but what an employee really should know. So they can understand their options and what truly constructive discharge is.
Okay, so Bill, for us laymen, for us non-lawyers in the group here, when you say constructive discharge, you're not referring to a business firing somebody because they have that right in California if it's not based on race or sex or anything like that. They just need to fire them. They fire them. It's not that. It's something else, right?
Well, in a way, let's work backwards. We know what discharge means, but what does constructive mean? Well, constructive means more or less not that you're a contractor and you're being fired for doing a lousy job putting up a wall, but no, it has to do with the fact that you are forced into doing something that you wouldn't otherwise ordinarily do, and that is you are quitting your job voluntarily, but you feel you have to because you have no alternative. You can't stand to be in the workplace that you're in anymore. And what's interesting about that, of course, is that term has been widely diluted because constructive discharge has an underpinning to it that is the mainstay or the foundation of being constructively discharged. Being forced to quit your job, saying I can't stand my boss is not one of them. And that's where I thought we'd go today, Steve and Rick, explaining what an employee goes through, and where is the limit, where's the line drawn to where he or she is actually constructively discharged.
All right. So why don't we start by saying, can you come up with scenarios where people would understand why someone who didn't necessarily want to quit work, because if that's their occupation that pays their living expenses, then that's a pretty important decision, when you're quitting a job, but why they feel compelled to do that?
There are a lot of different reasons, Steve, but there are the phony reasons and the good reasons. And let's start out by saying that an employer must, first of all, intentionally create a condition that he or she knows or promotes in such a manner that a reasonable person in the employee's position would find it intolerable and be compelled to resign. So a reasonable person in that situation would be compelled to resign. Why would that be? Well, a number of reasons. One, because you're of your sex or your gender or your race, you're being discriminated against to such an intolerable level that you can't work there anymore. National origin, we know the whole gambit of these things. Religion, medical disability, which, by the way, includes HIV/AIDS. We get a lot of cases now where people with AIDS are discriminated against. If you're over 40 years of age and you want to claim that you're being discriminated against because of your age, and of course a retaliation where you're a whistleblower and you're being discriminated against because you're reporting something that's a violation of law. So unless you have those underpinnings and are being forced to resign, at least you feel you are, because of those reasons, it's generally not going to work in a constructive discharge scenario.
So part of constructive discharge means you're leaving for a reason that most anybody on the outside of the business or the situation going might say, well, you could sue the company for that because that's not legal.
That's right. Because how many times do we have employees, Steve? And I tell you, I belong to a group called AVO. It's a legal group. It's online. I answer a lot of questions. I take a lot of calls and give people legal advice. And a lot of the calls that I get are, I just need some help. I can't stand this guy or this gal. I can't stand them. Well, you know what? Law in California is at will, barring any discriminatory conduct. So if you don't, it's difficult sometimes, but sometimes you have to tell this employee, if you don't like your job, go find another one. It's really that simple. Now, is it really that simple to find another job? Well, that all depends on your skill set and, maybe how old you are or whatever else might entail you finding another job. But essentially, an employee cannot complain about a nasty workplace. That's just not going to cut it. And that leads into a lot of lawsuits that end up being charged for phony or discriminatory reasons that don't exist. And those are the ones that have to be, ciphered out. You have to really be able to spot those things. And there are a number of different things that you can do to be able to spot those. And that leads us into what an employer needs to do to make sure that the bases are covered.
Okay, so if I understand this whole concept, what it sounds like it's largely based on is the intent of the people running the workplace and how that intent is perceived or maybe misunderstood or whatever by the employee that feels they're being targeted.
Right, and remember, an employee's perception can be one way, and an employer's perception another. The key really is there some legal underpinning that causes you to say, I gotta quit, versus I just gotta quit because this guy's I can't stand the person.
All right, so you could be working in a workplace environment. Maybe it's demanding. There's just the nature of the work requires you to be in maybe uncomfortable, environmental surroundings. You're working long and hard. You're getting sweaty. You're entitled to X number of breaks, but you don't feel like you can take them because the work pace is moving too quickly. and it's not something that's targeting you. It's something that everybody in that work environment deals with if they feel like they want to continue working in that business. One day you just decide, I've had it, I'm done, I'm quitting. You're quitting because you don't like the environment that the business creates as a function of doing what they do, but you're the only one that's opted out. Is that considered what you're talking about?
Well, yeah, in a way. In other words, if I understand your question, and I think it's a good one, you may be experiencing what everybody else is experiencing in the workplace, or you may be singled out because the boss just doesn't like you. But is that singling you out and not liking you, is that premised on some discriminatory basis, or is it just that the guy or gal doesn't like you? I mean, think about it this way. If you're in the workplace and you're being abused, what we would typically say is verbal abuse. The guy is swearing in the workplace, or he's saying that you're not doing your job well in front of other employees. He's making your life miserable to where your temperature goes up 10 degrees every time you walk into the office. The question you have to ask yourself is, would you be expected to be able to sue under those circumstances? So as two lay people, I'll put it to you and Rick. Do you think you'd be able to sue for those kinds of things?
I think if you can show some type of health, ramifications, because the way you're being treated at work and there's nobody else being treated this way is causing you to a point to have to leave that job because you're feeling ill effects somewhere else, I think you might. I don't know if you'd win or not, but I think you might.
Well, that's the perfect answer, because the real answer is no, you can't, unless the employer has some discriminatory intent behind the treatment. However, many people do, and this is where employers falter. You have to keep efficient records. You have to keep drop files to where you make notations about employees all year long. You have to give them yearly reviews, which come out of those drop files. That's what encompasses your yearly reviews. And if you do that, you can then fend off an employee who wants to bring a phony claim for constructive discharge, which is really based on some reason other than discriminatory conduct. So you have to be able to do that. On the flip side, the employee has to understand that working for a jackass is not against the law. And an employee has to keep the same kind of records of every kind of conduct he or she experiences to see if it will infiltrate a discriminatory foundation or a basis. And that way, the employee can then go to an attorney and say, hey, do I have a legal basis to sue? But being unhappy in your job is not a reason to quit your job. And then go ahead and try to make a claim. It is a reason to quit your job and go find another job, but it's not a reason to say, hey, I've been constructively discharged. No, right. You've quit your job voluntarily because you can't stand the place.
So if an employee in an organization, maybe the management is not, they're not that good. They make a lot of contradictory decisions. They change their mind. They don't seem like they're running a very smooth, predictable shop. And the people on the floor, the people in various departments are always feeling like they're just being put upon and asked to do more when sometimes it doesn't make any sense. So just because that condition exists doesn't mean that you could quit and then turn around and sue for a hostile work environment.
That's right. Exactly right. Does not exist. And now you work with a lot of businesses, Steve. Have you ever worked with a business where there's been a lot of turnover?
Oh, yeah. Yeah. Okay.
And have you worked with a business where the turnover has largely been because they don't run a smooth operation, or because they don't know what they're doing, and then that's why they called you in the first place?
Yep.
Well, there you go. That's a perfect example of somebody who might, in addition to that, be arguing with their boss all day long. And maybe they're miserable when they leave work. How many of us have all heard of people who say, I can't stand my job. I don't even want to go into the office anymore.
Oh, yeah. No.
Yeah. And that's where these phony lawsuits come from a lot of times. And I don't mean to project some sort of blessing on people who conduct themselves that way, employers, I mean. That's not the proper way to be, but that's not an offense that is the making of a constructive discharge?
Well, on some occasions, what I'll see is the person that has been identified as maybe not being an employee or a coworker that really seems to fit. You know, what usually happens is the things start to take place, like they start to miss work, or they're not really paying attention to what they're doing, so they're making mistakes or they're underperforming. And typically, what happens is the employer, because they've been schooled by their HR folks, they have to take them through a process. You sit them down, you try to figure out what's going on, but you have to make note of that. You have to record that, and then maybe you have to send the employee later on, if nothing changes, a letter of reprimand. And then that goes in the file as well. You have to go through X number of steps in order to be compliant, so that you don't invite lawsuits that are of your own making. And what that causes. At some point, the employees that are starting to see what's happening, the ones that are shrewd start to figure out, okay, I have to inject something into this process to protect myself from what I think is probably going to end up happening. So all of a sudden, they come up with a health condition that didn't exist before, and now by just simply inserting that into the conversation, you've created another obstacle for the employer to get around, because now that's known.
Yeah, well, here's a good example. Somebody makes up a health situation. They complain, my employer didn't take my health into consideration all of a sudden now, right? One of the things you're going to look at there, is the following. The guy had to quit. He left his job. He had to because the employer wouldn't help him. Did that person ask for a reasonable accommodation under the Americans with Disabilities Act? Because if that person didn't, then that shows in a way that claim never really was valid, because had that person gone through that hoop and really had a condition that was impinging upon their work and asked for a reasonable accommodation, and if that accommodation was reasonable and then denied by the employer, then you've got a discriminatory basis for perhaps a constructive discharge. But many people leave that one link out and come up with just what you said. There's a medical problem. I got to leave because this guy, is driving me crazy. Now I've got high blood pressure. I've got this. I've got that. Well, did you ever go to your boss and say, I've got this medical condition and I want you to help me out. I need a reasonable accommodation? Probably not, because if the basis of your disgruntledness isn't founded in a discriminatory basis, you're really just complaining about not liking the guy and therefore making up this medical problem as an excuse.
Well, and while I think that probably happens more than we'd like to know, I also, just to be fair to people that are honest and have integrity in an employee environment, I think the reason a lot of times why people don't bring these things to they don't bring them to their boss or to senior management is because they're afraid that once that illness or that disability that they might be, have just found that they're into is known, that the company's going to find a way to get rid of them anyway.
Well, then they've got a real cause of action. I mean, if you get rid of somebody who has honestly asked for a reasonable accommodation, then you can't just get rid of that person. If you do, then that's not a constructive discharge. That's wrongful termination, and now you do have a basis for a claim. But remember that even if somebody asks for a reasonable accommodation, and I don't want to get too far afield here, but even if you ask for an accommodation, it's got to be reasonable. It can't be a situation where it causes the business to suffer. If the employer can reasonably accommodate you and allow you to do your job differently and still allow his business to run smoothly, in effect, then that's a reasonable accommodation. But what I would always suggest, Steve, is that an employer not cause these hassles for employees by simply being rude and nasty, because that doesn't generate an atmosphere that's going to be conducive to making your business prosperous. It's going to give you a bad reputation, and it's going to bring you on the courthouse steps with phony lawsuits. Because let's put it this way, folks, I say this all the time in my business newsletters, you do not have to be in the wrong to be sued. You can be fending off a lawsuit and paying lawyers accordingly by being wrongfully sued. And yeah, you may get some of your costs back if you win, but you're not necessarily always going to get your attorney's fees back.
So, Bill, help our employees out there. Help them understand what resources or what avenues that they have. Let's say there is a health issue that's come up because of the work environment, and they need to communicate that with either directly to the employer or possibly the HR department.
Right.
What kind of options do they have?
Well, they should go directly to HR. If there is no HR and it's a small business, you go to the owner or your immediate supervisor, and you make the problem known and indicate that you've gone to a doctor. You have some doctor's notes. You have some medical records that, of course, they're going to want to see, and of course, they have a right to see. And then you say, as a consequence, you can see what my doctor said. He says my job needs to be changed in XYZ manner. You then ask the boss or the supervisor or HR if they can have you change your job or accommodate you, in other words, to be able to fit both your schedule in terms of going to the doctor and the performance of your work on the job. If it can be done, then it's done. If it can't be done, then it's up to the employer to show that he or she could not give a reasonable accommodation. And it's up to the employee to decide whether or not they want to proceed with litigation at that point. So I want to make sure that employees understand that this isn't just centered around employers, and I'm not advocating just solely for the employer. But I do get questions from a lot of employees who, let me put it this way, are less than genuine about their claim. And what I mean by that is they think because they have a nasty workplace situation that then generates the ability to litigate, and it doesn't. One other domino effect to this is, of course, if you are genuinely constructively discharged, if you do have a valid claim and you do leave your job, well, then, of course, under most circumstances, you're able to collect workers' compensation because it's like a typical regular discharge. If you don't have a constructive discharge and you violate, if you leave your job voluntarily, or if you claim a constructive discharge and it turns out not to be one, you're not going to get unemployment. So, and I have a number of unemployment claims now as we speak, just strictly unemployment claims, where people leave the job and all of a sudden a year later they're making a claim on workers' compensation insurance. Also, without ever reporting to the employer that there was a problem at the time they were there. Or many times there's a problem, but the problem is in a completely different area of the body that they're claiming workers' comp for at the present time. So, being an employer and running a small business, in addition to all the things we discuss on this show, making the business prosper, really involves making sure you have all your ducks in a row, not just in the field that you generate your living from, but making sure the business itself is run in a legal and profitable way. And that means that you should have a marketing consultant, a lawyer, and an accountant on your team, because 9 times out of 10, in fact, I go so far as to say 99.9 times out of 10, whatever we discuss on this show centers around or combines in marketing, legal, and CPA analysis. It all comes to the forefront. So I hope our listeners have gotten some benefit from this, and more particularly employees who always ask me this question. I think if they listen to this show, they'll get a pretty well-rounded idea of when and when they don't have a valid claim. Okay.
Yeah.
That's my closing thought for the show. I can't stress enough that if people need help in this area, I'm happy to discuss it with them. I do give free consultations, and I'm also available on AVVO. That's avvo.com. You can look at my profile, give me a call, and I'm happy to help anyone out that I possibly can.
Well, this is a great.
Well, Rick signed off early.
Yes, Rick signed off early. I believe something happened to his camera equipment. So Steve and I are left, and we're going to say goodbye, everybody. We hope you I hope you enjoyed the show, and we'll see you here same time next week, same place. Have a prosperous and fantastic week.
Take care, Bill. Good show. Thanks for your input.
Thanks, Steve. See you next week.
Bye-bye.